Hello, I'm Sister Tandy. Most employers do not choose to be non-compliant. They simply do not know the cost. They assume that occupational health obligations are administrative formalities, things that can be dealt with when there is time, when the budget allows, when the urgent things settle down. Today, I want to have an honest conversation about what happens when compliance is deferred. Not to frighten you, but because the numbers, the legal realities, and the human consequences deserve to be understood clearly. Knowledge is the foundation of good decisions. Let's begin. The Occupational Health and Safety Act specifies significant financial penalties for non-compliance. Contravening the Act or failing to comply with a compliance notice issued by an inspector constitutes a criminal offense. Upon conviction, an employer may be fined up to 100,000 rand, imprisoned for up to 1 year, or both. Repeat offenses attract higher penalties. Under the National Prosecuting Authority's approach to corporate liability in South Africa, juristic persons, companies, can be held criminally liable, not only individual directors. Under certain provisions of the Companies Act, directors may face personal liability if they knowingly allow non-compliant conditions to persist. These are not theoretical risks. Department of Labour prosecutions are a real and growing feature of South Africa's compliance landscape. Beyond criminal penalties, non-compliant employers face significant civil liability exposure. The Compensation for Occupational Injuries and Diseases Act, COID, provides a no-fault compensation mechanism for injured workers. Registered employers contribute to the compensation fund, and injured workers claim from that fund. This shields employers from many common injury claims. However, COID protection is not absolute. If a worker can demonstrate that the employer's willful act or gross negligence caused the injury, and non-compliance with known safety obligations may constitute gross negligence, they may bring a separate civil claim for damages. Additionally, an employer who is not registered with the compensation fund or has arrears in contributions is not protected by COID and is fully exposed to civil claims. Compliance with COID registration and contributions is therefore both a legal obligation and a financial shield. A prohibition notice issued by a Department of Labour inspector can be the most immediately damaging consequence of non-compliance. When an inspector identifies a hazard that poses a risk of serious injury or death, they can issue a prohibition notice that immediately and legally stops the affected operation. Not after a hearing, not after a period of remediation, immediately. The notice stays in force until the inspector is satisfied that the hazard has been eliminated. In construction, this can mean a stopped site with standing labour costs, contractual penalties, and deadline breaches. In manufacturing, it can mean halted production lines with downstream supply chain consequences. In food processing, a prohibition affecting hygiene standards can cascade to retailer contracts. The cost of a single prohibition notice in a medium-sized operation can easily exceed the annual cost of full OHS compliance. South Africa's procurement landscape increasingly incorporates supplier compliance scoring. Large corporates, listed entities, and government departments frequently require OHS compliance certification from suppliers and contractors before awarding contracts. A failed Department of Labour inspection, a reported incident, or a prohibition notice may disqualify a business from tenders and supplier lists. In construction and mining, principal contractors are legally required to ensure that all subcontractors on their sites comply with OHS requirements. A non-compliant subcontractor exposes the principal contractor to liability. This means that your OHS compliance status directly affects your ability to win and retain contracts. Compliance is not only a legal requirement. In today's procurement environment, it is a commercial prerequisite. Behind every statistic about non-compliance, there is a person. A parent who went to work in the morning and did not come home. A worker whose hearing was gradually destroyed over 10 years of noise exposure because no audiometry was ever conducted. A family navigating disability because a hazard that could have been controlled was not. The Department of Labor reports thousands of occupational injuries and hundreds of fatalities annually in South Africa. Research consistently shows that the majority of workplace incidents are preventable, not by luck, but through the systematic hazard identification and medical surveillance required by the OHS Act. Non-compliance is not an administrative oversight. It is a choice that affects the health and lives of real human beings. And that is the most important reason to comply. Let me help you calculate your real non-compliance exposure. Consider a medium-sized manufacturing business with 150 workers. Annual OHS compliance investment, policy development, risk assessments, medical surveillance, training might cost between 150,000 and 250,000 rand. Now consider the cost of non-compliance. One prohibition notice, production losses, at conservative estimates could reach 500,000 rand within a week. One occupational injury claim under COVID combined with a civil claim for gross negligence, potential liability of 1 to 5 million rand. One prosecution and conviction, fine up to 100,000 rand plus legal costs. Reputational damage affecting contract pipeline, variable but potentially career-defining. Compliance is not the expensive option. Non-compliance is. Here is your practical compliance audit. 5 things you can do in the next 5 working days. Day 1. Retrieve and review your health and safety policy. Is it current? Is it signed? Is it displayed? Day 2. Confirm your health and safety representative is appointed in writing and your committee is meeting. Day 3. Pull your risk assessment register. Is it less than 12 months old? Does it reflect the actual hazards on your site? Day 4. Review your medical surveillance status. Which workers are exposed to hazards that require medical monitoring? Are their certificates current? Day 5. Check your COID registration and contribution status. Are you registered? Are your returns submitted and up to date? 5 days, 5 actions. That is the foundation of a compliant workplace. CareNet consultants can assist you with Day 4 in full. The most resilient compliance programs are not driven by fear of inspectors. They are driven by a workplace culture where everyone, from the CEO to the newest worker, understands that safety is a shared value, not a management function. When the managing director attends the safety committee meeting, it signals that safety matters. When a supervisor stops a task because a risk has been identified and is praised rather than pressured, it signals that compliance is protected from above. When a worker reports a near miss without fear of blame, and the organization responds with investigation and improvement rather than punishment, it signals that the human cost is understood. Ubuntu. I am because we are. One compliance officer does not build a safe workplace. It is built by every person who arrives and makes a choice, today, to see the hazard, report it, and act. Before you go, here is something from the research. A study published in the Journal of Occupational and Environmental Medicine found that workers in organizations with strong safety cultures report significantly lower rates of musculoskeletal disorders, mental health conditions, and fatigue-related illness. Safety culture is health culture. From all of us at CareNet Consultants, your best is good enough for today. See you in the next video.
CareNet Consultants,
your partner in workplace health.